Welcome to Sriram's IAS. Today, the topic for discussion is Attorney General of India and Advocate General of India. So, the Office of Attorney General of India and Advocate General of India, what are the constitutional provisions? Okay, we'll find out. So, the Office of the Attorney General of India, the Constitution provides for the Office of Attorney General of India under Article 76, Part 5 of the Constitution. Part 5 is related to the Union Executive. So, the Attorney General of India is a part of the Union Executive and he is the highest law officer in the country. Whereas the Advocate General, Article 165 provides for the Office of Advocate General of the State under Part 6 of the Constitution. Part 6 is related to the State Executive. So, the Advocate General of the State is a part of State Executive and he is the highest law officer in the state. What about the appointment of Attorney and Advocate General? Okay, so Attorney General of India and Advocate General of the state. So, the appointment of Attorney General of India is made by the President of India, whereas the appointment of Advocate General of State is made by Governor of the concerned state. Now, what about the qualifications relating to both Attorney General of India and Advocate General of the state? So, the qualification for a person to be appointed as an Attorney General of India is he should be qualified to be the Judge of the Supreme Court. Okay, so the Constitution provides for the qualification of the Judge of the Supreme Court. So, these are the qualifications. Let us discuss the qualifications. So, what are the qualifications? He should be a citizen of India and he must have been a judge of some high court for 5 years or an advocate of some high court for 10 years. Okay, and also an eminent jurist in the opinion of the President. Okay, so these are the qualifications relating to the Judge of the Supreme Court. The Constitution does not mention the minimum age for the Judge of the Supreme Court. So, a person to be appointed or qualified to be appointed as a Attorney General of India should be qualified to be a Judge of Supreme Court. So, the Constitution provides the qualifications of the Supreme Court, Judge of the Supreme Court, that is, he should be a citizen of India, he must have been a judge of some high court for 5 years or an advocate of some high court for 10 years and an eminent jurist in the opinion of the President. Now, what about the qualifications of the Advocate General of the State? Okay, so under Article 165, he should be qualified to be a judge of the High Court. So, the Constitution provides the qualification for the judge of the High Court. So, what are the qualifications? He should be a citizen of India. He must have been a judge or he must have been in the judicial service of the state for 10 years or an advocate of a high court for 10 years. Okay. So, the qualifications are qualifications for the judge of the High Court as provided by the Constitution are he should be a citizen of India, must have been in the judicial service of the state for 10 years, an advocate of the High Court for 10 years. But the Constitution does not provide the minimum age for the judge of the High Court. But unlike the Supreme Court, the qualification, that is an eminent jurist in the opinion of the President, okay, so this qualification of an eminent jurist is not available or not given to the judge of the High Court. So these are the qualifications. What about the tenure? Okay, regarding the Attorney General of India and Advocate General of the state. So the Constitution has not fixed the tenure, okay, of the Attorney General of India. So he or she holds office during the pleasure of the President. Okay, when he and she holds office during the pleasure of the President. So the pleasure of the President, he holds office during the pleasure of the President. It means that he or she can be removed at any time by the President. Okay. So, the tenure is not fixed by the Constitution and he or she holds office during the pleasure of the President. Same, the Advocate General of the state, the Constitution did not fix or the tenure of the Advocate General of the state and he or she holds office during the pleasure of the Governor. That is, an Advocate General of the state can be removed at any time by the Governor since he or she holds office during the pleasure of the governor. So what about the salary? Okay, remuneration. Okay, the remuneration is not fixed by the constitution, and the Attorney General of India receives such remuneration as the president may determine. Okay, so what about the Advocate General of the state? Same. The remuneration or salary is not fixed by the constitution, and he receives, the Advocate General of the state receives such remuneration as the governor may determine. Okay, so this is about the salary and remuneration. What about the resignation? Can the Attorney General of India or Advocate General of the state resign? Yes, they can resign by addressing, or they can resign, that is, they can quit. They may quit by addressing the resignation or submitting the resignation to the president. The Attorney General of India may quit by submitting the resignation to the president. The Advocate General of the state may quit or resign from the office by submitting the resignation letter to the governor. Conventionally, the Attorney General of India, he or she resigns when the government or Council of Ministers resigns or is replaced. Okay, so since he is appointed by the government, that is by the president, and holds office during the pleasure of the president, the pleasure of the president is nothing but under Article or under 42nd Constitutional Amendment Act. Okay, the president shall act according to the aid and advice of the Council of Ministers headed by the Prime Minister. So conventionally, he or she resigns when the government, that is Council of Ministers, resigns and is replaced. Okay, so Article 74 and 42nd Constitutional Amendment Act. So the pleasure of the president is nothing but aid and advice. Okay, so the Council of Ministers, when they resign or are replaced, he conventionally resigns. Same, the governor. Conventionally, the Advocate General of the state, he or she resigns when the government, that is Council of Ministers, resigns or is replaced. So the pleasure of the governor is nothing but the advice, aid and advice of the Council of Ministers headed by the Chief Minister. So the governor here is bound by the aid and advice of the Council of Ministers headed by the Chief Minister. So the replacement of the Council of Ministers or resignation, he or she, that is the Advocate General of the state, resigns. Okay. Now what about the removal procedure? Does the Constitution provide the procedure or grounds for removal? No. The term of office is not fixed. You already know the term of office is not fixed by the Constitution, and the Constitution does not mention the procedure and grounds of his removal. That is, the Constitution does not provide the ground and procedure for removal of the Attorney General of India. That is, you already know that since he holds the office during the pleasure of the president, he is appointed by the president, and he holds office during the pleasure of the president, he conventionally resigns when the Council of Ministers is resigns or is replaced, because the pleasure of the president is nothing but the aid and advice provided by the Council of Ministers headed by the Prime Minister. So same with the Advocate General of the state. The term of office is not fixed by the Constitution, and the Constitution does not contain the procedure relating to the procedure or grounds for his removal. Same, since why? Because he is appointed by the governor and he holds his office during the pleasure of the governor, and the governor is bound by the aid and advice of the Council of Ministers headed by the Chief Minister. So when the Council of Ministers resigns or is replaced, conventionally the Advocate General of the state also resigns. Now what about the duties? Duties of the Attorney General of India and Advocate General of the state. So duties and functions. Okay, what are the duties and functions? The duty and functions of the Attorney General of India are advice to the Government of India. He provides or he gives advice to the Government of India upon legal matters by reference of the President. Okay, whenever the President refers to the Attorney General regarding the advice upon legal matters. Okay. Same. The Advocate General of the state provides advice to the state government on legal matters referred by the governor. Okay. And the Attorney General of India performs such other duties of legal nature or legal character that are assigned by the President. Okay. So he performs such other duties of legal nature, that is legal characters, that are assigned to him by the President. Advocate General of the state also performs other duties of legal character that are assigned to him by the governor. Okay. And the Attorney General of India discharges the functions conferred on him by the Constitution or any other law. Okay. Same with the Advocate General of the state. He discharges the functions conferred on him by the Constitution or any other law. And the Attorney General of India appears on the behalf of the Government of India in all cases in the Supreme Court and High Court in which the Government of India is concerned. Okay. He appears on the behalf of the Government of India in all cases in the Supreme Court and High Court in which the Government of India is concerned. Same with the Advocate General of the state. He appears on the behalf of the Government of state in all cases in the Supreme Court and High Court in which the Government of state is concerned. Same with the Attorney General or same with the Advocate General of the state. And here the Attorney General of India, he represents of the Government of India in any reference made by the President to the Supreme Court under Article 143 of the Constitution. So what is Article 143? Article 143 is the advisory jurisdiction of the Supreme Court. The Constitution authorizes the President to refer any matter to the Supreme Court for its opinion. Okay. So on two categories. Okay. The President is authorized by the Constitution. So he can refer any matter to the Supreme Court for its opinion with respect to two. That is, this opinion is required or opinion is taken from the Supreme Court with respect to two. That is, it is categorized into two categories. That is, in any matter of law or fact. Okay, in any matter of law or fact in the public interest. Okay, and also with respect to pre-constitutional treaty, covenant, agreement, etc. Okay, so this is the advisory jurisdiction of the Supreme Court, where the Constitution authorizes the President to refer a matter, okay, to the Supreme Court for its opinion. So, with regarding to a matter related to the fact, okay, it may not give its opinion, but regarding to a pre-constitutional treaty, okay, pre-constitutional treaty or agreement, covenant, the Supreme Court has to give its opinion, and the opinion of the Supreme Court is not binding. It is just advisory. Okay. Okay. So this is regarding the duties and functions of the Attorney General of India and Advocate General of India. Now, what are the other aspects relating to the duties and functions? Okay. So, is the Attorney General full-time counsel or is he allowed private practice? Okay. Is he a government servant? Same. Is the Advocate General of State a full-time counsel? Is he categorized as a government servant or can he do private practice? Let's find out. Okay. So the Attorney General is not a full-time counsel. That is, he is not a full-time representative and does not fall in the category of government servants. Okay. So he is neither a full-time counsel or full-time representative of the Government of India, nor does he fall in the category of the government servants. So he can carry out his private legal practice. Okay. Same, the Advocate General of the state. The Advocate General of the state also is not a full-time counsel of the state. He does not fall or he is not categorized as a government servant, and also he can carry out his private practice, private legal practice. Okay. So what about the audience? Audience before all the courts. Okay. And what about the proceedings of the parliament or the proceedings of the state legislature, let's find out about the immunity and privilege also. Okay. So, does he has the right to speak. The Attorney General of India has the right to speak and take part in the proceedings of the parliament, that is both Lok Sabha and Rajya Sabha. He has the right to speak and take part in the proceedings and their joint sitting also, and a committee of the parliament of which he is a member, but without the right to vote. Okay, so he can take part in the he has the right to speak and take part in the proceedings of both the house of the parliament, that is Lok Sabha and Rajya Sabha, and their joint sitting, or any committee of which he is a member, that is any committee of the parliament of which he is a member, but without the right to vote. Same. What about Advocate General of the state? He has the right to speak and take part in the proceedings of the state legislature, that is Legislative Assembly and Council of States, and any committee of the state legislature of which he is a member without a right to vote. Without the right to vote. Okay. So, what about the audience in all courts? Yes, the Attorney General of India has right to audience. That is, he is entitled to appear in all courts in the territory of India. Whereas Advocate General of the state, he has the right to audience before any court of law within the state. Within the state. That is, he is entitled to appear before any court within the territory of the state. So, what about the immunities, privileges and immunity? Yes, the Attorney General of India enjoys all the privileges and immunities that are available to the member of the parliament. Whereas Advocate General of the state, he enjoys all privileges and immunities that are available to the member of the state legislature. Okay. So, what are the limitations of the office of the Attorney General of India? Okay. He should not advise or hold a brief against the government of India. Okay. So, he should not hold and not advise or hold a brief against the government of India. He should not advise or hold a brief in cases in which he is called upon to appear or is called upon to give advice or appear on the behalf or for the government of India. Okay. So, he should not advise or hold brief against the government of India. He should not advise or hold a brief in all cases in which he is asked to give his advice or appear for the government of India. Okay. And he should not accept an appointment as a director of any company or corporation without the permission of the government of India, and he should not defend the accused persons in criminal prosecutions without the permission of the government of India. Okay. And also, he should not advise any ministry or department of the government of India or any statutory organization or public sector undertaking unless a reference, okay, unless a proposal or a reference through the Ministry of Law and Justice, Department of Legal Affairs. Okay, Department of Legal Affairs. So, he cannot advise any ministry or department of the government of India or any statutory authority or any public undertakings unless or through a proposal or reference made by the Ministry of Legal Justice, Department of Legal Affairs. Okay. So, these are the limitations on the office of the Attorney General of India. So, what about the Solicitor and Additional Solicitor General? Okay. So, the Solicitor General and Additional Solicitor General assist the Attorney General of India in the fulfillment of his official responsibilities. Okay. So, they assist. And what about the office of Solicitor and Additional Solicitor General? Where is there any constitutional provision? No. Only the office of the Attorney General is created by the Constitution, that is Article 76. Article 76 does not mention the Solicitor General and Additional Solicitor General. Okay, so these are not, there is no constitutional provision belonging to Solicitor General and Additional Solicitor General. They assist the Attorney General of India in the fulfillment of his official responsibilities. Okay, so this is regarding the Attorney General of India and Advocate General of India. Okay, thank you.